Hey, I'm Paul Rabley, and in this video, we're going to talk about part 3 of our 6-part series on how a single or unmarried person protects their estate and qualifies for long-term care Medicaid if they go into a nursing home. Okay, so I've got the playlist in the description for the other parts of our 6-part series, but part 1 was about the big picture, part 2 was about the inventory of assets and income, but now we're going to get into the nitty-gritty of where assets get transferred to. So let me back up a little bit. So when a single individual, and when I say single, I mean unmarried, maybe it's a surviving spouse, maybe it's somebody who got divorced, maybe it's somebody who never got married, but they're wanting to protect what they have and not have to consume it all if they happen to go into a nursing home in the future. So to qualify for Medicaid, long-term care Medicaid, when somebody goes into a nursing home, in general, they have to have less than $2,000 of countable resources. Check part 2 for what that means. And they have to have not made any transfers of resources in the previous 5 years. So there's other rules, but that's the two big ones: less than $2,000 of countable resources and no transfers of resources in the previous 5 years. Okay, so that means that, most of the middle class, they have some assets and they have more than $2,000 of countable resources, and they have some exempt assets like a home that they want to protect from the state's estate recovery rights. So there comes a time where you have to make a decision. Okay, I'm going to transfer some assets so I can be eligible for Medicaid if 5 years from now I'm in or need to go into a nursing home. But where do I transfer those assets to? That's what this part is all about. So people who do it kind of informally and kind of do it themselves, they really think there's only one option. That option being, I'm just going to take everything I've got and put it in my children's names. I'm going to put all my money in my children's names. I'm going to put my investments in my children's names. And I'm going to put my house and really everything else I own into my children's names, maybe other than my checking account, which only has a few $1,000s in it. So what people don't like about putting stuff in your kids' names is that loss of control, because you never know what's going to happen after you take money and assets that have, some significant fair market value out of your name and put them into your children's names. Now you're at the mercy of your children's spending habits, perhaps their spouse's spending habits. You're at the mercy perhaps of their debts. Perhaps you're at the mercy if your children get divorced. God forbid if your children pass away and your assets then go along to your children's heirs. Or sometimes parents put things in their children's names and then relationships go sour, either from the parents to the children or among the children. And those children, or at least one or more of them, are not cooperative after they've received this money or these assets. And there's some tax reasons that make it not a good idea to put appreciated assets in your children's names, because they will get what's called a carryover basis. So if you bought a share of stock for $10 and today it's worth $50, if you just put that share of stock in a child's name, their basis for tax purposes will be whatever your basis was, let's call it $10. And whenever they sell that share of stock, either during your lifetime or after you die, they're going to pay a significant amount of capital gains tax. So, and in addition, here in Louisiana, if you put your home in your children's names, they're going to lose the homestead exemption. They're going to lose the opportunity to sell the home and exempt the first $250,000 of gain from capital gains tax. So you're probably starting to recognize that people get real uneasy when they start to consider whether they should take everything they have and just put it in their children's names in anticipation of qualifying for Medicaid if they go into a nursing home in the future. People are uneasy about that. So what most people do who, seek the right kind of legal help, for a few reasons, they transfer assets to a particular type of trust instead of transferring assets directly to their children. And when I say they transfer assets to a trust, not just any trust, and in particular, the question we get a lot, transferring your assets to the kind of typical avoid probate revocable living trust, that doesn't protect the assets from the nursing home expenses. Every state in America has Medicaid regulations that says if your assets are in a revocable living trust and you have access to those assets to be able to take them back, do whatever you want to with them, well, the Medicaid regulations are going to say you got to spend those assets if you go into a nursing home. So you have to set up a very particular type of trust, really one that was designed and customized with the specific intent of not being one of your accountable resources if you go into the nursing home in the future. So these trusts have a number of different names. There's no one official name for this type of trust, but maybe the name that best describes this type of trust is what I'll call the irrevocable income-only trust. So there's a number of factors that go into creating that trust, but typically one is that once the assets go in the trust, you're still entitled to receive all of the income that the trust assets produce, for the rest of your lifetime. So if you have a $200,000 CD that produces $2,000 of interest in a year, 1%, then that $200,000 CD is in the trust. It produces $2,000 of interest or income in a year. You would get that because you would be the one entitled to the income from that trust. And then the trust is likely to say, and again, kind of my disclaimer here, Medicaid is a federal program administered by the individual states. I live and work in Louisiana. You're going to want to check with really somebody like me in your state to make sure that you follow your state's rules. But I'm pretty sure every state has in their Medicaid rules a provision that says if you put assets into a trust, you can never have access to the principal of that trust, or you're not entitled to withdraw principal from the trust and put it back in your name. If you have the right to undo it and put it back in your name, they can make you exercise that right. So it's usually one of these what's called irrevocable income-only trusts, and typically the children are what's called the principal beneficiaries of that trust. And so when it's set up right, those assets in that trust are no longer countable resources of yours. Yes, you've made a transfer that triggers the 5-year time period penalty, but in an ideal situation, you're doing this while you're healthy, and so you're starting that 5-year time period, and in an ideal situation, that 5 years will pass before you ever have to enter a nursing home, so that when you do enter the nursing home, you will not have made any transfers within the previous 5 years. Also, what people like about transferring assets to this particular type of trust, also from a tax standpoint known as a grantor trust, is you're still treated as the owner of the assets for income tax purposes. So you still get that income. You would report that income on your personal income tax return. The trust doesn't owe any tax or pay any tax. And there are no tax or no income tax consequences to your children or the principal beneficiaries of the trust. So the idea behind transferring assets out of your name to a trust, the trust of which is not a countable resource of yours, but you retain an element of control over that trust. Your children have no right to spend the trust assets. They can't give them away. They don't have access to them, perhaps unless the trustee gives them access to those trust assets. So that trust vehicle, when it's the right kind of trust, it seems to work well for families. It gives you that element of control, knowing that the assets aren't going anywhere, at least not until you pass away, but they're no longer your assets for long-term care Medicaid purposes, but you do reserve that right to the income, and then you report that income on your tax return. Some people ask, Paul, does it make sense, or Paul, I heard that transferring my assets to an LLC would protect them. So, I get that question from time to time, and, I'm not going to go into the nitty-gritty details, but I guess my 2 quick points are, if you transfer assets to an LLC, every LLC has owners that are called members. And if you are the owner or member of the LLC, then that interest in that LLC is still a countable resource. You haven't taken anything out of your name or removed it from your estate. So if you own the LLC, that doesn't do you any good. If you transfer assets to an LLC which is owned by your children, then that's going to trigger all of these income tax consequences to your children every year, and it's just going to be more complicated than it needs to be. Most parents, they want to set up an arrangement that doesn't cause any complications or any tax consequences to their children. They like to try to keep things as simple as they can, and that's where this trust vehicle can really accomplish most, if not all, of what a parent is trying to accomplish when they're trying to protect what they have for themselves, for their children in the future, but retain some element of control and even perhaps retain income rights if that's desired. Okay, so there are a number of decisions to be made when you do establish a trust like this. Who's going to be the trustee? Who's going to be the alternate trustee? Who are going to be the principal beneficiaries? And I don't want to dig too deep in this video because I know that state law can vary slightly from state to state on the Medicaid rules when someone transfers assets to a trust in an attempt to make a transfer of resources and have those resources no longer be countable resources. So real important now that you subscribe and hit the notification bell so you won't miss anything in the future. Of course, give it the thumbs up. You can, comments down below. Just know that if you ask some kind of detailed legal question, I'm not going to answer it, but maybe if you give me some ideas in general to discuss on future videos, I can do that. I don't want to try to give individual advice based on a 1 or 2 or 3 sentence question, certainly without me understanding the big picture of what's going on with someone. So that was part 3. Part 4, also a really important part of this 6-part series. It's going to be what assets should get transferred and what assets you should keep. So pay attention to that. I'm gonna publish a video in this 6-part series once a day, 6 consecutive days, 10 a.m. Central Time each day. All right, hope that helps. We'll see you next time.